Hello and welcome to Part 1 of the NC State and FTCOE's virtual workshop series on qualifications of an expert witness for legal professionals. Today's workshop will focus on the Daubert Standard, with presentations scheduled every hour between 9 a.m. to approximately 3 p.m. Eastern. Each presentation will be directly followed by a brief Q&A session, and a 1-hour lunch break will occur between 12 p.m. and 1 p.m. Eastern. Up first, we will hear from Jim Agar with the Defense Contract Management Agency on the history and admissibility of forensic expert testimony. Without further delay, here's Jim.
Good day, everyone. My name is Jim Agar. I'll be your host today for our discussion of the admissibility of expert witness testimony in contemporary federal and state courts. I'm a retired Army JAG colonel who had 25 years on active duty, both defending and prosecuting courts-martial, and followed that up with some 7 years at the Federal Bureau of Investigation at the FBI laboratory, where I trained and worked with forensic experts from virtually every discipline imaginable there at the FBI. Now, I work with the Defense Contract Management Agency as a fraud attorney, but forensics is still near and dear to my heart. All right, well, let's talk about what we're going to discuss today. The roadmap is right there before you, and you can see we're going to go through the legal standards for admissibility of expert testimony. Both Fry and Daubert and the Federal Rule of Evidence, we'll talk about all of those, plus an antecedent to those cases, which is Kumho Tire, which not many people know about, but it's an important case to discuss. I'll then go through the different expert witness attributes that are looked upon by courts in determining whether to admit or deny the expert testimony of a person who is testifying before them as an expert witness. We'll then go through a series of case studies, and these case studies will examine the examiner's testimony, and then also the examiner's discipline in terms of admissibility and what courts may look at when making that determination. Finally, we'll look at best practices of all examiners and the things I recommend that those examiners take to heart when testifying. And last but not least, we'll talk about the changes on the horizon coming up in the next year or so. So we start first, of course, with the legal standards for expert testimony. There's basically two standards that exist in this country. The first is the Fry standard and the other is Daubert's. You'll hear them used differently and they may apply in different jurisdictions. I will tell you up front, Fry is the older of the two standards, Daubert is the newer of the two, although those are relative terms. So let's go through a basic recap of what those two standards entail. Well, the Fry test has been around for a century now. It started in federal district court in the District of Columbia with a case involving what was then a lie detector. The defense wished to have this expert testify about a lie detector that they had subjected their client to, and it showed their client was being truthful when he was saying he didn't commit the crime. The DC court weighed this, and on appeal, it determined that only expert testimony should be allowed that was sufficiently established to have gained general acceptance, and you'll notice I have emphasized those words in gold, general acceptance in the particular field in which it belongs. Now, this particular test became known as the Fry test, and virtually every state adopted it subsequent to 1923, and of course all the federal courts followed it as well. To this day, you'll still find a number of jurisdictions still follow it. Now, the federal courts have abandoned the Fry test, but California, Illinois, Minnesota, New York, New Jersey, Pennsylvania, and Washington, to name just a few, still follow the old Fry test of general acceptance. A lot of states have recently changed away from the Fry test, Maryland being one, the District of Columbia being another. The state that I'm in now, Florida, just switched to a Daubert test back about a year ago. So we see a shift consistently from states to the Daubert test, which we'll discuss later, and away from the Fry test, which we're discussing now. So the Fry test is the minority position of most jurisdictions. It still exists in about 20% of all states, and you may see it from time to time. All right, the next test we'll look at, though, comes through Federal Rule of Evidence 702. I talked to you about the Daubert test, but the Daubert test was spawned as a result of Federal Rule of Evidence 702. In the 1970s, the federal courts undertook a reorganization of the rules of evidence to harmonize them and unify them throughout all the district courts in the United States. The result was the Federal Rules of Evidence, which became effective in the 1970s. One of those rules is right here, Federal Rule of Evidence 702. And you can see how it lays out, as it were, a roadmap for the courts in determining whether to admit or deny the expert testimony proposed before it. It talks about the specialized knowledge or technical skill or scientific knowledge of the expert being able to help the trier of fact understand the evidence. It has to be based on sufficient data and facts. And of course, it has to be the product of reliable principles, and the expert has to have reliably applied those principles. So, for example, you could be the best astrologer in the world, but if that's not reliable principles and methods, even if you are the best astrologer, the court would probably exclude you as an expert witness. Conversely, you could be an examiner who testified about, say, DNA, something which is universally accepted by just about every court. But if you suck as a DNA examiner, or you did something wrong during your examination and you have not reliably applied the principles and methods of a DNA examination to a case, the court may find that you cannot testify as a witness pursuant to Rule of Evidence 702. So this rule came into existence in the 70s, and really nobody took big notice of it until along came the 1990s. And in 1993, the Supreme Court finally came down with the decision of Daubert versus Merrill Dow Pharmaceuticals. Now note, this was not a criminal trial. This, in fact, was a civil lawsuit that was being brought by plaintiffs against Merrill Dow Pharmaceuticals for the manufacture of a drug called Bendectin. My tongue gets tied on that. The court came back and noticed that the lower courts had used the old Frye test to weigh the admissibility of whether an expert could testify to the actual product liability in this case. The court said no, the Frye test is not applicable here. In fact, we are jettisoning the Frye test, and it was jettisoned once Federal Rule of Evidence 702 was adopted by the federal courts. Relevance and reliability are the touchstones of that particular rule, and then the court gave us 5 factors to consider when determining admissibility. Now, the court went on to say that not all factors must be satisfied for a court to determine that an expert could testify, but it also pointed out that that application applies equally to scientific and technical experts. Well, here are those 5 factors right here. The first is one called testability. Is it possible to replicate that particular process or technique in order to test it and see if we get the same results? 2 plus 2 should always equal 4 after all. If somebody else gets 5 or 3, then obviously it can be tested, but it's not very reliable. Next, the court looks at whether the subject or discipline has been subjected to peer review and publication, the known rate of error, which is a big thing that courts look at all the time. And if it has one, great. If it doesn't, well, then why doesn't it have a rate of error? Are there standards published that exist to control a technique's operation? And has it gained widespread acceptance in the relevant scientific community? Now, that last point is very similar to what we saw in the Frye test. So we're seeing that Frye hasn't been completely abandoned altogether. An aspect of it still remains, but now the court has set forth a number of different guidelines. And that brings us to the case that followed some 6 years later, Kumho-Tyer versus Carmichael. A lot of courts grappled with how to apply Daubert. They didn't know what to do with the factors. Was it gospel? Was it a checklist? And the court came back and said, you're overcomplicating things. Number 1, Daubert applies to all witnesses, scientific, technical, or otherwise. You could be a perfume sniffer or a coffee taster. Daubert is still going to apply, and we're going to utilize those factors. But the court said it is a flexible inquiry. Not all the factors may be applicable in all cases, and there may be some cases like the perfume sniffer who comes in as an expert witness, but he or she wouldn't have an error rate. They wouldn't necessarily have anything in a peer-reviewed published journal. It might not even be testable, but that person could still be an expert if they have some type of specialized knowledge. The thing the court left with the audience was that the Daubert factors are not a definitive checklist. Flexibility remains key, the judge remains the gatekeeper, and the court pointed out that even if shaky expert testimony is admitted, there is still the avenue of cross-examination and presentation of contrary evidence to deal with that, as well as potentially instructions by the judge. So the application of those 5 Daubert factors really depends on the circumstances of the case. So let's get an example of how a court might weigh something. This is the movie My Cousin Vinny. Now you'll note it's released about a year before Daubert comes out, but there's actually a pre-admissibility hearing that occurs right in front of the jury, which actually does occur sometimes. And we can see for ourselves exactly how that occurs. So this is My Cousin Vinny, and we'll see how it works.
Your Honor, the defense calls as its first witness, Ms. Mona Lisa Vito.
Oh, I object, Your Honor. This person's not on the witness list.
This witness is an expert in the field of automobiles and is being called to rebut the testimony of George Wilbur. Your Honor, would you please instruct the bailiff to escort Ms. Vito to the witness stand, please?
Hold up your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yeah.
Ms. Vito, you're supposed to be some kind of expert in automobiles, is that correct? Is that correct?
You please answer the counselor's question.
No, I hate him.
Your Honor, may I have permission to treat Ms. Vito as a hostile witness?
You think I'm hostile? Now wait till you see me tonight.
Do you two know each other?
Yeah, she's my fiancée.
Well, that would certainly explain the hostility.
Your Honor, I object to this witness. Improper foundation. I'm not aware of this person's qualifications. I'd like to voir dire this witness as to the extent of her expertise.
Granted. Mr. Trotter, you may proceed.
Mm-hmm. Oh, Ms. Vito, what's your current profession?
I'm an out-of-work hairdresser.
Out-of-work hairdresser. Now, in what way does that qualify you as an expert in automobiles?
It doesn't.
Well, in what way are you qualified?
Well, my father was a mechanic. His father was a mechanic. My mother's father was a mechanic. My 3 brothers are mechanics. 4 uncles on my father's side are mechanics.
Ms. Vito, your family's obviously qualified. But, have you ever worked as a mechanic?
Yeah, in my father's garage, yeah.
As a mechanic? What you do in your father's garage?
Tune-ups, oil changes, brake relining, engine rebuilds, rebuild some trannies, rear end.
Okay, okay. But does being an ex-mechanic necessarily qualify you as being an expert on tire marks?
No. Thank you. Goodbye.
Sit down and stay there until you're told to leave.
Your Honor, Ms. Vito's expertise is in general automotive knowledge. It is in this area that her testimony will be applicable. Now, if Mr. Trotter wishes to voir dire a witness as to the extent of her expertise in this area, I'm sure he's gonna be more than satisfied.
Okay.
All right, all right. Now, Ms. Vito, being an expert on general automotive knowledge, can you tell me what would the correct ignition timing be on a 1955 Bel Air Chevrolet with a 327 cubic inch engine and a 4-barrel carburetor?
It's a bullshit question.
Does that mean that you can't answer it?
It's a bullshit question. It's impossible to answer.
Impossible because you don't know the answer.
Nobody could answer that question.
Your Honor, I move to disqualify Ms. Vito as an expert witness.
Can you answer the question?
No, it is a trick question.
Why is it a trick question?
Watch this.
Because Chevy didn't make a 327 in 55. The 327 didn't come out till 62. And it wasn't offered in the Bel Air with a 4-barrel carb till 64. However, in 1964, the correct ignition timing would be 4 degrees before top dead center.
Well, she's acceptable, Your Honor.
Your Honor, this is a picture taken.
Okay, that gives you an idea of what it can look like when you're dealing with qualifying an expert witness. Now, none of the Daubert factors came up here, but you will notice that they inquired into her education, her experience, and her training. Those are the things you're going to look at for an expert witness. Now, the Daubert factors might have applied here. Obviously, we've got a technical witness as opposed to a scientific one, but that expertise is clearly well-grounded, and the field of auto mechanics is something nobody's going to question as being a truly technical field. So what is it that the courts are looking for when an expert testifies? Again, education, experience, and training. Those three things are the most key to a witness being accepted as an expert. But the court may delve into other things as well, and I've got a laundry list here for you. Has that witness taken a proficiency test? Did they pass, or did they fail that proficiency test? Is the lab where they're working accredited? Are they certified independently by a body like latent print examiners, or certified by the International Association for Identification? Do they have awards? Do they belong to any professional organizations which allow them to continue their education? And then also, have they taught at some time? And then the most important one I think you can have, other than the fact that you have, in fact, the right education, experience, and training, is have you testified as an expert before? And last but not least, are you published in the field? All of these may make a difference in determining whether you could testify as a witness. So remember, if you are called to testify, you're a witness. Remain a person of science. You don't have any victim to avenge, no guilty person or innocent person to convict or save. Simply testify as to the results of your examination. Testify truthfully, and do so within the limits of science. I leave you with this quote here that is provided by ASCLD Lab, which is the accrediting body for the vast majority of laboratories here in the United States. So let's transition now into some of the case studies I talked about before. We'll go into case study number 1, which is U.S. versus James Cloud. Cloud was a Native American who went on trial in Indian country there in Yakima, Washington. This case went to trial in 2021, 2022, and it was right there in the courthouse there in Yakima. Mr. Cloud had a cousin by the name of Donovan. The two of them were a two-person crime spree. They killed, we believe, at least 5 people in and around Yakima, Washington, but there was no really good evidence. And in fact, what happened is that at some point they stole a Honda Civic from a person that they were not affiliated with whatsoever. That person's body was found. He had been shot with a .22 caliber rifle, if I remember correctly, and they recovered the rifle. The problem was they couldn't tie Mr. Cloud to the actual murder scene, except for one thing. On the rear view mirror of that Honda Civic was a perfect latent fingerprint from the thumb of somebody. That particular rear view mirror was removed, brought to the FBI laboratory, and examined. And the result by the forensic examiner was that that particular print was linked to Mr. James Dean Cloud. The latent print examiner identified him as the source of the latent print on the rearview mirror and put that in her report. There was a verification done by another examiner. It was a blind verification. So we have 2 examiners saying this is his print. So now he's linked to the crime scene. There was a problem, though. The forensic examiner in that case had committed a prior casework error in a different case. She had falsely excluded a latent print when she should have identified it. Next, she failed a proficiency test shortly thereafter, and she was subjected to a correction action review and received 2 bad poor performance reviews at that time. Now, this all occurred around the time her mother passed away. Her mother died of COVID. She was under a lot of pressure at that time, working long hours. She was tired. Probably should have been removed from casework, but she wasn't. So now the question comes up, what do you do with this examiner who has a bit of a checkered past? At this point, she had testified previously on 10 occasions as an expert witness, and now up for her 11th time, the court was going to scrutinize her. What did they find? Well, her testimony at the Daubert hearing was quite telling. They found that she took a second proficiency test, and on the stand under oath, she said that she didn't require any assistance. But the defense, who had been provided all the documents concerning her corrective action review and her employment performance reviews, revealed that her supervisor actually had given her some assistance in completing the proficiency examination. When confronted with this, she made that correction, but you'll notice what the court said. They were worried that she made that correction in her testimony only after being confronted with documentary evidence of said consultation. That's an integrity issue. So she's already got an issue with a failed proficiency test. She's also got a problem here also with having made a mistake on casework. And then basically the court finds that there's an integrity issue here too. So the court decides that while they're sympathetic to the fact that she had her mother pass during all this time, they could not qualify her as an expert in this particular case. And mind you, this is a capital murder case. You got to have all your ducks in a row for a case like this. With the proficiency exam issue, the error that she had made, and then the lack of integrity, the court found that she could not testify as an expert witness. And the court's decision was that she was not qualified. Although the court did permit another government expert to testify, and in that case, the person who conducted the blind verification came in, testified without issue, and that was it. Mr. Cloud was convicted in court, and his cousin pled guilty shortly thereafter. So that was the court's decision. This particular examiner was not able to testify in this case. Whether that examiner ever testifies again remains to be seen. Usually after a finding like this, it's pretty hard to come back. Then next, case study number 2 is one where the examiner over testifies. What do we mean by over testifying? Well, that's when an examiner exaggerates. They claim too much in their testimony. They go beyond what their findings are in the case file and state things that just can't be supported by the science. Well, this is the case of U.S. versus Marlon Williams, which occurred in Washington, D.C. So, Williams allegedly shot Min Soo Kang 5 times in the Cadillac Escalade, purportedly to steal the Escalade. He does drive away in the Escalade, and at the point the Metropolitan Police Department are contacted, they then contact General Motors, and the OnStar disables the vehicle immediately. And at that point, Mr. Williams exits the vehicle. Unfortunately, he's seen at that time. The Escalade is found to have blood, 5 bullet holes, and lo and behold, they have latent prints in the vehicle that are identified as belonging to Marlon Williams. 3 bullets are recovered from the Escalade. They then get a search warrant, and the Metropolitan Police Department is able to find a high-point pistol in the same caliber, 9mm, that was found at the crime scene where Mr. Kang was shot. All right, so this is submitted for examination to what is then the Department of Forensic Science at Washington, D.C. More about that later. 3 bullets recovered from the Escalade are compared to known bullets fired by this high-point pistol recovered from Mr. Williams. The forensic examiner in this case, Luciano Morales, says they are a match. The case goes to trial. Williams is convicted of murder. He appeals. And there you can see the 9mm high-point weapon right there before you. Now, the appellate court has an issue with Morales' testimony. This case actually goes up on appeal twice, Williams 1 and Williams 2. But in the second case, the court has real problems with his testimony because they're looking at it from a different perspective. A couple of new reports on firearms have come out which are skeptical, and they're now in a Daubert jurisdiction versus a Frye jurisdiction. Well, first of all, Morales testified that firearms leave unique identifying marks. That part probably is okay, maybe. He then says they're a match to those recovered from the Escalade. Probably a little bit questionable at that point. You could say match, but that implies that there's no other bullets it could match to. And then he says that these bullets were fired from this firearm. Probably still okay, maybe, we don't know, but he's exaggerating perhaps, as opposed to hedging his bets and saying could have been fired or something like that. But then he's asked if he has any doubt, and he says, no, sir. Those bullets were identified as being fired out of exhibit number 58, and it doesn't matter how many firearms High Point made. Those markings are unique to that gun only. Well, the court wasn't buying that, and they said basically he'd gone overboard. And the court's decision was that in this jurisdiction, a firearms and tool market expert may not give an unqualified opinion or testify with absolute or 100% certainty. They then held that it was error to admit this opinion testimony, and the case was remanded. So here we have an examiner that went a bridge too far, that testified to things that could not be supported by his discipline, nor by his examination, nor his experience, education, and training. Mr. Morales had never examined every firearm in the world, let alone every high point 9mm pistol in the world, or even that in the District of Columbia. So how then could he say that it was unique to that firearm and that firearm only? I leave you that because that type of exaggeration, even if it was a good examination, probably cost the prosecution its case and also may have cost Mr. Morales' job. The Department of Forensic Science in Washington, D.C. shut down in 2021. It lost its accreditation, and part of it was because of sloppy casework such as this. All right, we then go to case study number 3, which is the court intervention in Abrukwa versus State. This is out of the Maryland Supreme Court. It came down about a month and a half ago. Very new case. It's been on appeal off and on now for about 4, 5, 6 years, something like that. So it's been bouncing around in the Maryland appellate courts for some time. It starts back in 2013. At that point, Abrukwa was convicted of killing his roommate with a .38 caliber Taurus revolver, which you see pictured here. Now, at the time he's arrested, he says, yeah, I own that revolver, but he didn't admit to actually firing it or killing his roommate. There's a jailhouse informant that says he confessed, but that's probably worth whatever weight the court wants to give it. But the point is, in the first case, and yes, there was more than one trial, Abrukwa doesn't object to the firearms testimony. There's no appeal on the expert testimony issue, but the case is reversed on other grounds and he goes back for a second trial. Well, the second trial occurs in 2018. At this point, he does object to the testimony of firearms examiner Scott McVeigh. Mr. McVeigh did not actually testify at the second trial because he testified at the first, and so the Sixth Amendment requirement for the Confrontation Clause was met by that first time. But the court does conduct a 4-day admissibility hearing going through the vagaries of firearms examination. Having gone through that 4-day hearing, they uphold the firearms identification discipline, and McVeigh's testimony is read into evidence about 4 bullets and 1 bullet fragment recovered from the crime scene at some point were fired from the Taurus revolver. Abrukwa was convicted a second time. He appeals again. This time, in between that time of his conviction, Maryland converts from a Frye to a Daubert jurisdiction. Before there was a Frye-Reed test, now they've got a Daubert test. So the court remands to the circuit court now. They demand another admissibility hearing, which they conduct, and now that appellate court decides that firearms identification is okay. They uphold the conviction, and then the Maryland Supreme Court intervenes. And the court basically holds that based on the record here and the lack of evidence that studies that exist are not reflective of actual casework, firearms identification has not been shown to reach reliable results. The court cites that there was an analytical gap between the examiner's opinion and the evidence of the case, and because of that, it overturned the conviction again. Now, that analytical gap is not one of the Daubert factors. What happened is that when Maryland took over Daubert, it added 5 additional factors to the test. So the states may have a different variant of Daubert that's at work here, and that's exactly what occurred with Abrukwa. The analytical gap issue is one the court may cite to as a means to say, we don't think the examiner could get there based on the evidence that we've seen. Therefore, we're not going to allow it. In the Abrukwa case, the court said you couldn't identify somebody with a firearm, a particular bullet or cartridge case, as having been fired by a specific firearm, but you could testify that it could not be excluded or that it could be one of the firearms that did potentially fire that bullet or cartridge case. So let's talk about the best practices for witnesses, but that gives you a flavor through those case studies. One is a witness who was found wanting. Second is the testimony of the expert witness that was found wanting. And third was the discipline itself that was found wanting by the court. Each of these is going to be an inquiry under Federal Rule of Evidence 702 that the court can make. All right, so the best practices for an expert witness, well, they're out there. This is Jim Agar's recommendations on best practices and ones that have been time tested at the FBI laboratory. Number one, know your limits. Obviously, the examiner in Williams did not know his limits. He testified beyond them and he got into trouble because of that. Know what those limits are. Today, a lot of labs employ testimony review. That's good. When you get criticism, take it well, but know your limits. If you don't know about DNA and you're just a latent print or trace evidence examiner, don't talk about DNA. Know your limits. Stay in your lane. Number two, if you don't know anything about the limits, you will find out you will suffer the consequences at some point, and that's what we're seeing here. Admit your mistakes. I've never seen a perfect case before. I've never seen a perfect examination before. Things go wrong. There may be a deviation from policy. There may be something that went wrong with the collection of the evidence. We just don't know. But if there are any mistakes in your case, admit them. The defense probably already knows about it, and hopefully the prosecution does too. It shouldn't be a surprise to anybody, and candidly acknowledge your mistakes. And a good example here is the case of the Japan Airlines flight from 1968 that, well, I would say crashed or more likely landed in San Francisco Bay. Captain Aso, who was flying this particular flight, failed to adjust the barometric altimeter upon departure from Tokyo. On final approach to San Francisco, the altimeter was telling him he was about 200 or 300 feet higher than he actually was above ground level. As a result, he landed this DC-8 in the middle of San Francisco Bay on a rock ledge about 10 or 12 feet deep. Nobody was hurt. Nobody was killed. The aircraft actually flew again after this. But the National Transportation Safety Board brought in Captain Aso, and they asked him to explain what happened. And in his own broken English, he said to the NTSB, Aso, well, you can see for yourself what his comment was, messed up. And he said it no less than 5 times to the NTSB. When it was over, the NTSB decided that Aso had not received the proper training on using the barometric altimeter, that Japan Airlines should have trained him better. They found there was no pilot error, and he was restored to flight duty, flying an additional 15 years as a pilot for Japan Airlines without a single mishap. The point being that integrity is important for experts and professionals. If you lose that integrity, you may lose your license. If you maintain that integrity, then good things just might happen. This particular fact scenario was taught at the Harvard Business School. Now, let's go forward to 2013. Exact same situation happened with Asiana Airlines Flight 213. They failed to reset the barometric altimeter. When they came on to final approach to San Francisco, they crashed the plane right there short of the runway. The plane was destroyed. 3 people died. Flight crew said, we weren't trained properly on the barometric altimeter. It wasn't pilot error. And the NTSB said, no. Pilot error, you will never fly again. Integrity matters. Admit your mistakes. Number 3, the best examiners, the ones who've been at the lab for 20 or 30 years, have 3 words that I love. I don't know. And they're very candid about using those words. They will freely admit there are things they just don't know or would have to speculate about. Don't be afraid to say, I don't know. 3 hardest words for a supposed expert to say, but if you don't say them, you can get into trouble real quick. So embrace opportunities to say, I don't know, or I can't tell you. I just don't have the answers. That's okay. You have permission to say, I don't know. And last but not least, always tell the truth. That's your job. That's a requirement. Don't forget about it. So that brings us up to our next position, which is changes which might be on the horizon. Well, we've got a couple pending right now that you should be aware of. And the first of these is going to be an amendment to the Federal Rules of Evidence effective the 1st of December of 2023. Yep, we do amend these every so often. The last one was probably about, 20 years ago. But we're now seeing significant amendments here. And one of them is to Federal Rule of Evidence 702, which we discussed before. Well, here it is, folks. It becomes effective in about 6 months or so. And you can see that it specifies that it changes a couple of things, and it specifies that the burden of proof to demonstrate that a particular discipline is reliable is on the person or party proposing to call that expert witness. So the burden is on, if you're a prosecution witness, the prosecution to demonstrate that that particular expert witness testimony is reliable. Now, before we always assumed that was the case, but now it is explicit that that is the case. So if you're called as a witness, the government, and the government is calling you as a witness, then you'll have to have the government actually demonstrate that your testimony and your discipline is reliable. If you're called by the defense, then the defense would have that burden to demonstrate again by a preponderance of the evidence that your testimony, that your scientific discipline, and the principles are all reliable. Go to the bottom, though, on number D, and you'll see there is a change there, that the expert's opinion reflects a reliable application of the principles and methods to the facts of the case. I've highlighted that. I think that's the more important of the two, because I think it is a bit of a game changer. We saw the Abrukwa case where the Maryland Supreme Court said, you cannot testify to identification. We don't think your opinion reflects a reliable application to the principles and methods. There's too big an analytical gap for us. That's what subpart D is talking about. And that's what we may see more of in the future, is that instead of just looking at the admissibility of the expert's testimony, they may also be looking or scrutinizing the reliability of the opinion of the expert. So look for more of that. I think we've given you a good flavor of what was going on in the past, and now you're going to see what's going on in the future as well. Okay, next, the Department of Justice Uniform Language for Testimony and Reporting. This has been around for about 5, 6, 7 years or so. Nothing new, except it's updated all the time. If you have a discipline which is mentioned here, you need to be aware of the uniform language for testimony and reporting, or alters. It's online. You can see what DOJ is using. These uniform standards exist for the FBI laboratory, for the DEA laboratory, and the ATF laboratory. They should also be something that every other laboratory manager should be taking into account. What areas do they cover? Well, you can see the firearms examination right here. This was updated just this year in 2023, but you can see it covers a multitude of disciplines, from anthropology to metallurgy, DNA, footwear, hair and fiber examinations, even glass. And there's different variants under each of these categories. So you have subcategories also that cover this. What do they cover? Well, first of all, they talk about acceptable language in which to convey your opinion, but they also do something else. And that is, they also tell you what language is off the table. Specifically, individuals cannot testify to absolute or 100% certainty as to their conclusions. Remember the case of U.S. versus Williams? That's a no-no, and it's clearly spelled out here. Next, you can't testify to the exclusion of all others in the world. How can we say that this latent print or this DNA is unique to the exclusion of all others in the world when we've not looked at all the other prints in the world? We haven't seen all the DNA samples in the world. The best they could do is say it's identification, but it's possible, theoretically possible, that yes, another print does look like this, or that somebody else's DNA does look like this. In fact, when we look at DNA, we know that exact twins, identical twins, do have the exact same DNA, so it is possible that somebody else could have that DNA. Examinations are not infallible. There is no such thing as a zero error rate, and the list goes on and on of different requirements that individuals, or limitations that individuals have placed on them when they testify. Why is this important? You don't work at the FBI lab, you're not testifying for the Department of Justice. Well, first of all, you might be called to testify in federal court, in which case the Department of Justice will use these ultra limitations and educate you on those limitations. Second, even if you're not, if you're in state court, you may be cross-examined on them. And there may be questions asked about, do you follow these limitations? Do you believe in these particular limitations on your testimony? And you're going to have to answer that question at some point. So my recommendation to all examiners is, look at the alters, review them, get to know them, especially the up-to-date versions, and that way you won't be surprised on the stand by the prosecution or by the defense. So those are some of my recommendations, and right now I'm going to go to any questions you may have. Thank you very much for your time. I hope this has been instructive. If you need to contact me, you can reach me at jimbo.agar@yahoo.com. Thank you for your time and attention. I hope this presentation has been educational.
Good morning, everyone. Thank you for joining us today for our part 1 session in Daubert rulings. And thank you, Jim. That was really great. I actually learned a lot. So now I'm going to have to go look up the older limitations for myself. I am Dr. Ann Ross. I'm a board certified forensic anthropologist, and I work at North Carolina State University. To start off our Q&A, actually there were some really interesting questions that actually just jump off, were a couple that you addressed. So here's one. I'm going to start with this one because you finished up with this. One attendee asks, you mentioned, let me see, is it here? That if, in your opinion, should prosecutors, defense attorneys, and judges be well-versed in the DOJ's uniform language testimony and reporting? And should jurors be trained on the alter to better assess the weight of expert testimony?
Good question. When it comes to the alters, I think the defense counsel and the prosecution should both be aware of them. And I think it's a good practice to employ them in cross-examining or conducting a direct examination of a witness. The judges may or may not be aware of them. We often will provide a copy in court to the judge, have them take judicial notice of it. The jury's not so much. Sometimes they'll be educated about the alters during the testimony of the witness. Usually, at least in the FBI laboratory, we will specifically lay out what limitations are imposed on our witness testimony, so the jury knows that right up front with the testimony itself. And sometimes we'll have judges write out instructions explaining what things the expert witness can or cannot testify to. So there's no, one-size-fits-all solution to that answer, but I think a general awareness by all the parties, including the juries, is certainly warranted.
Thank you. And here's another question, but this one is about the FRAE 702 with the changes that are happening. And someone asks, how will states be affected by the upcoming amendments? And will states be affected differently depending on whether they follow the FRAE or Daubert standard?
So I think it won't change that much with the states, because with the change in Federal Rule of Evidence 702, some states automatically amend their evidence code to conform to the federal code. Others will wait and either at a later time potentially adopt those amendments, or maybe never adopt those amendments. Or in the case of Maryland, for example, we saw Maryland adopted the Daubert factors and then said, well, we're going to add a couple of more as well. So it's really going to be dependent upon the state. And I wish I could say there's a uniform standard out there. But even when it comes to Daubert, we find that there are variants and subvariants of that at the state level. Now, the good news is at the federal level in U.S. District Court, those rules are uniform. But I think with the state courts, we could see some variants out there. I do think that the changes in 702 will begin to open the door on the court inquiring more about how the expert reached their opinion, and potentially limiting the scope of that opinion or conclusion testimony, and potentially even rewriting it to some degree, which is of some concern to me. We've seen that in the past, and in the Abrukwa decision, I think we're seeing it there too.
Thanks, Jim. Let's go to our poll questions now, and then if we have time, I can ask the other questions that the attendees have.
And I think the first question is, can a latent print examiner identify a specific person as the source of a latent print left at the crime scene? Okay, there are the numbers. That's awesome. Appreciate the feedback on that. Okay, thank you very much. And there's number 2, a DNA examiner can identify a specific person as the source of DNA found at a crime scene? And these are not trick questions, just so you know that there's no right or wrong answer. It's just looking for your opinion. Very similar numbers, interesting. Very similar, slightly higher on the agree as opposed to latent print examinations, but very interesting. Okay, great. Moving on to question number 3, I believe. A firearms examiner can identify a specific gun as having fired a bullet or cartridge case found at a crime scene. These are all pattern matching evidence is what we refer to it, or feature comparison disciplines, where the examiner looks at something, whether it's DNA, a latent print, or a cartridge case or bullet, and then compares them to a known sample, and then makes a determination based upon that examination or comparison. Okay, numbers again. All right, very interesting, very illuminating for me. I'm always intrigued to see people's opinions. All right, now let's move on to question number 4. Yes. So this gives us a couple of different versions of firearms examiner's testimony, which we've seen that the courts have put out. So we talked about limitations, and sometimes the court won't let an examiner testify to identification. And in the past, we've seen some of this language come forward. Sometimes they'll say that the firearm cannot be excluded as being the source of a fired bullet or cartridge case, that they may have fired that bullet or cartridge case, that the marks on that bullet or cartridge case are consistent with those on a specific bullet or cartridge case, that it's more likely than not that that firearm fired a particular bullet or cartridge case. And lastly, the traditional version, which is that the firearm has been identified as the source of that bullet or cartridge case. So which of those do you find most helpful, or for that matter, perhaps most accurate in that testimony? Because those variants we have seen from a variety of courts, both state and federal, and that's the spectrum that we're looking at with some of the courts. Okay. And there is the poll. That is very intriguing. That is intriguing. So consistent with comes out as the all-out favorite at 63%. And the traditional version of identified only at 16%. That is fascinating. Okay. And I think, do we have one more question out there, or is that it? We do. Okay. Okay, so this is a couple of options we've seen. Again, courts do a variety of things, and they find an examiner's testimony is not reliable. Should they exclude the examiner's testimony, limit that examiner, or edit or rewrite the examiner's testimony? We've seen all 3 of those things occur at one time or another in a court. Which of those 3 is the most appropriate remedy? Okay, and we're getting our results. Exclude the examiner's testimony is the overwhelming favorite at 74%. I would agree with that. I think that's what Daubert specifies. I think it's sort of a binary choice there of either exclude or admit the testimony. But a significant chunk of people are saying, hey, limit the examiner's testimony, kind of like what we saw with the DOJ alters earlier. And that's a fascinating result as well. So I thank you, everybody, for participating in that poll. That gives me some insight into people's opinions. And sometimes we get buried in the weeds here. So I do appreciate that.
Yes, and we have a participant that put in the chat if you will go over the responses and some of these questions.
Okay, sure. Okay. The responses to the poll we just saw earlier, or which one?
Yes.
Okay. Oh boy, where do we begin? I think, when it comes to identification, that has sort of been the basis for most opinions we've seen in feature comparison disciplines. Certainly with DNA, most examiners, in fact, virtually all examiners talk about identification, with the caveat that we can't say it's that person to the exclusion of everybody else. Usually they relay that opinion in the form of a statistic, whether using random match probability or probabilistic genotyping. Doesn't matter. both of them report back their identification, opinion, or conclusion in the form of a statistic. And usually that's like 1 in 26 septillion or something like that. And then that can convey to the jury how likely or unlikely it is that that's the individual's DNA that was left at the potential crime scene. Latent prints are a bit different. The examiner then does issue a conclusion or opinion of identification, but the examiner does not give a statistical support for that particular opinion or conclusion. It is a subjective determination, which renders it somewhat suspect, I think. But you have to remember, it's also been demonstrated to be fairly reliable at that point. And we're now showing that the algorithms that are behind the next generation identification program, whereby the FBI has all the information on fingerprints in its database, are actually more accurate than the examiner's conclusions. We see an error rate of less than 0.5% for the examiners. I think for NGI, the error rate is going down to 0.1% when it calls an identification. And actually, NGI doesn't say identification. It gives you a candidate list and says, here are the top 3 or 4 or 5 or 10 candidates, and they're rank ordered. And it's based upon the number of candidates that's requested from the examiner. But we're finding NGI is doing an exceptionally good job of finding whose latent print that may be. With firearms, that's also subjective determination. I think firearms is probably more suspect because of 2 things. Number one, there's no objective criteria to determine identification. And that is something that the discipline has suffered from some time. I don't see it changing in the future. They've tried to create objective criteria for identification. Nevertheless, it has an error rate hovering around 1% of false positives, which is pretty darn good. So it's not quite clear how the examiners get to those conclusions, but they do so with remarkable accuracy of 1% or less of an error rate. So it's commendable. So I would respond to all that and just give that there for your edification. Okay. Dr. Ross, anything else? What else do we have?
We have a few questions in the Q&A.
Okay.
So let's see, you've already answered some of these. One individual asks, according to the word inconclusive,
Yes.
is much too variable in the jury's understanding. There should be a lot of qualification to how the opinion is consistent.
Yeah, inconclusive is a tough one for some people because there are times when we've examined bullets or cartridge cases that clearly were not fired by the same gun, but the criteria requires us to find it's inconclusive because it was the same, it has the same class characteristics such as the caliber, the weight of the bullet, or the shape of the cartridge case, things of that nature. So they were consistent with one another, and so we can't exclude on that basis alone. AFTI is trying to go to a 5-point scale from just identification, inconclusive, and exclusion to having a graduation between different levels of inconclusive. I'm not fond of that. I think that allows the jury some wiggle room, and I think it could potentially open the door to convictions on evidence where the accused may not have fired that particular firearm, or we may not have a real association there. So it gives the jury a false sense of security, if you will. So I do like the bright line rule of saying either identification or inconclusive. But yeah, it is an ambiguous term. And we don't know when the examiner says that, are they just unsure? Do they not lack the expertise to truly identify it? Or is it because there were insufficient marks laid on the cartridge case or bullet to conduct an examination? And we do know, for example, the Glock pistols don't mark particularly well on the bullets. On the cartridge case, they do a pretty good job of marking. But that could be a good example of an inconclusive result that comes about there. And so we do see that in a number of examinations. And I wish the inconclusive rates weren't as high as they are. And I think we're looking at probably around 16, 17% on most of those exams. But that's par for the course because we don't want to falsely identify something when conducting an examination.
Yeah, that's interesting because in forensic anthropology, we always say consistent with or not consistent with, right? When we do tool mark analysis on bone, that type of thing, because
Right.
it's also pattern analysis. Yes. So two individuals asked about the word individual and individualized.
Yeah, there's some debate that goes on about that. When we individualize or say it's that person, how is that different from saying it's unique or an identification? And to me, this is my personal opinion. It's a matter of semantics. I think once you say it's that individualization, you're saying it's unique to that individual only and not to anybody else. What I do like about the term identification is that you're saying we're identifying as that individual, but you're not saying it's unique or individualized because it could also identify another individual or another firearm. And so that's one thing to keep in mind about the term identify, is that it could, in fact, bring up some issue of it being another firearm or another person who may have fired this firearm or may have left that latent print at the crime scene. It just depends.
Yes. And someone else asked, certainty is on its face not scientific. What does the prosecution do to prevent defense counsel from suggesting that proof beyond a reasonable doubt requires scientific certainty?
Well, I think scientific certainty is something we strive for. I think it's a good goal. Getting there is another matter. And that is, I think sometimes you're not going to have certainty in a lot of things. If you had certainty, the case would have been a guilty plea. Okay, let's be honest. I mean, the accused would have confessed. We'd have, video from the crime scene and everything else. That's what you're talking about with certainty. But you don't get cases like that very often. In fact, I don't think I've ever had one in my entire career. So when it comes to scientific certainty, I think the best we can do is have these caveats that we acknowledge that this is not this person's latent print or this firearm to the exclusion of all others. We show the limitations of the science, and we're honest about that with the jury so that they can make an informed decision. Because the last thing we want is for them to convict somebody based upon bad information or bad evidence. So I think full disclosure by the examiner is in order here, to talk about the potential pitfalls of the discipline and also the strengths of it as well. And then just let the jury decide. My philosophy in trying cases is give the jury all the information possible, lay all the cards on the table, let them decide. And then based on that, accept the verdict. At least they did so knowing everything and being aware of all the evidence and how much weight to give it in their own opinion.
Thank you, Jim. And unfortunately, everyone, we have run out of time. So please feel free to reach out to Jim with your questions. And thank you so much for a wonderful presentation.
Thank you very much, Dr. Ross. Have a great day.